Peter, nice to see you again.
You too,
Uh,
Trevor.
yeah, after a year full of intermittent podcasts, it's become a little bit of a habit and a very pleasant one from my point of view anyway.
Absolutely. Nice way to end of the year.
Yeah, and I must say I've had feedback from friends who are not particularly tax people. They all said, gee, that guy Peter Dachs is fantastic.
I don't know which podcast they're watching, but anyway.
we can draw the inference from that. But anyway, okay, our topic today is the Thistle case. Now, we did do it, I think it was the second podcast we ever did, which was the tax court decision. And this is now the Supreme Court of Appeal decision. And perhaps I should say at the outset that I know that the taxpayer has applied for leave to appeal to the Constitutional Court. And just heard that SARS has also applied for leave to cross appeal on the question of penalties. Now, there was a concession about when it came to penalties. So I don't know how you cross appeal something when it's been conceded in court, but anyway. So perhaps this logical starting point is to just very briefly reminisce the facts and deal with the judgment of Judge Wright in the Gauteng tax court. The situation we had here was that there were a number of, they're called tier 1 trusts. I think there were about 8 or 10 altogether. And then there were a number of, those were all what can be termed vesting trusts. In other words, the beneficiaries had vested rights to both income and capital. Then Thistle was one of the discretionary trusts that was a beneficiary of those tier 1 trusts, and they were called what was it? It's named in the judgment. They were called the Zen Prop Group, and apparently they own a lot of land in Santon. You probably found that your firm's offices are owned by these trusts, but they own a lot of real estate in that part of Santon. That's what I was told. Anyway, so the capital assets were sold by the tier 1 trusts, and the Thistle Trust received its share of the net capital gain. And it received it not by virtue of the trustees exercising their discretion. They received it as of right because it had vested rights to that. The trustees of the Thistle Trust then immediately declared or awarded that amount to its beneficiaries who were resident beneficiaries in South Africa. And it was common cause that the tax was paid by those resident beneficiaries. And SARS, relying on paragraph 82 of the 8th schedule, said no, that says that the trust disposing of the asset must disregard any capital gain, and the trust the beneficiary must take that capital gain into account. It was common cause that the way in which the beneficiary trust took it into account was by awarding it to its resident beneficiaries. That we had a statement of agreed facts. And that tax court decision, it's the fastest judgment I've ever had. Literally, we got judgment 2 days after the hearing. It's an absolute world record for me at any rate. And Judge Wright held that Section 25 capital B1, which refers to any amount, and I think most of our viewers will be familiar with what Section 25B talks about. It says where an amount's been received for the immediate or future benefit of a beneficiary, whether by virtue of the exercise of a discretion or not, it's deemed to accrue to that beneficiary. And to the extent that that's not the case, it's deemed to accrue to the trust. And he held that those words were sufficient to capture a capital gain, and therefore the amounts were deemed to accrue to the resident beneficiaries in terms of paragraph 82, read with section 25B1. And so the taxpayer was successful, and then the question of penalties fell away. I can remember the date of the hearing of the Supreme Court of Appeal judgment, and let me say something positive before I say anything negative, which I'm afraid I'm not going to be able to avoid. The hearing was on the 2nd of September, and the judgment was delivered on the 7th of November. So September, October, November. So it's over 2 months, which is a long time for the SCA. Given there are 5 judges there, and they all have to read it, so judgments tend to come out a lot sooner. And the positive thing I'd like to say is we came away from that hearing that we got a very good hearing. It was polite. Both parties had a chance to express what they wanted to say, and the court listened, and no problem about the hearing. That's not always the case in Bloemfontein. Sometimes certain judges like to be finished by tea time. As it happens, that we were actually finished by tea time, but that's just because it was a very contained issue. And so we waited for the judgment, and we all expected Judge van der Merwe to give the judgment, because he was doing all the talking. He was making the running at the hearing. And my opponent said to me that the judge, there are 5 judges involved, but the judge, if you look and see whose registrar is sitting as registrar of the court, that's a sure indication of who's going to write the judgment. So we were expecting a judgment from Judge van der Merwe, and then along comes Judge Hughes, who's very recently been appointed a full permanent judge in the SCA. And if I say this judgment is disappointing, that's putting it very mildly. I really can't say anything nice about it. But there are certain blatant errors, and where something might go on appeal, one doesn't want to sort of preempt anything, and usually one just keeps quiet. But there's some such obvious errors that one cannot fail to point them out. So she narrated the facts. And if you see what happened, I almost think that, let's just say, one of the judges started writing the judgment and couldn't command a majority of the judges, and so then Judge Hughes took over. I don't know, I'm speculating now. But I'll tell you why I say that in just a moment. In paragraph it's footnote number 3 in the judgment, so it's really early on, and I suspect that this was written by the other judge. The point is made, and I'm reading footnote 3 now. It says section 26A provides that, quote, there shall be included in the taxable income of a person for a year of assessment the taxable capital gain of that person for that year of assessment, as determined in terms of the 8th schedule. Now, we all know that that's the case. So you determine taxable capital gain, and it then comes into taxable income. And the court has quoted that here. So there's no doubt about that. However, let me quote from paragraph 19 and 20 of the judgment. Paragraph 19, the learned judge says the following: when examining subsections 25B1 and 25B2 to determine what any amount, those are the words used in section 25B1, constitutes, the sections must be read as a whole. Section 25B3 provides insight into the amount that the legislature was concerned with in the application of this section. That amount was the taxable income derived by way of any amount. Section 25B, read in its entirety, demonstrates that the amount is of a taxable income nature and not of a capital gains nature. Any amount will thus not include capital gains. Now that's a direct contradiction of what's in footnote 3. Footnote 3 says taxable capital gains come into taxable income, but she's saying now 25B refers to items of a taxable income nature, not of a capital gains nature. That I think everybody would agree that is simply wrong. Then in paragraph,
can I just come in there, Trevor, just to
of course,
chat about it? So I think because for me the crisp issue is whether the concept of an amount in section 25B1 includes amounts that constitute a capital gain. I think to me that's kind of the narrow question.
Yeah,
and I think in your paragraph 20 or 21, the judge said, or the court said, that the law specifically, or that provision specifically excludes amounts of a capital nature. But to me, what was striking is that at the time of the transactions, 25B had not been amended. So it talked about amounts, and it did not say amounts which do not constitute or which are not of a capital nature. It didn't have those words at the time.
No.
And there's no reference to that in the judgment. And I found that very surprising, because I think they should have picked up on that and said at the time, there was no specific exclusion of amounts of a capital nature. However, this inclusion, which subsequently happened, either was retrospective or it was purely clarificatory in nature, but just not to deal with that, I found very surprising, especially when section 25BA, capital B, capital A, very similar provision, but deals with CISs, that deals with collective investment schemes and securities effectively that are trusts. And it's always had the wording an amount excluding an amount of a capital nature. So you can put section 25B as it read at the time next to 25BA, and you can say that one excludes amounts of a capital nature, the other one doesn't at the time of the transaction. So I think you need to explain that away if you're writing a judgment, is kind of my sense of reading it.
Absolutely. And if you look at the definition of gross income, it's the total amount in cash or otherwise, but then it goes on to exclude amounts of a capital nature. So clearly that includes capital. And if you look at paragraph 35 of the 8th schedule, it talks about receipts and accruals, and then subparagraph 3 excludes any amounts that have been taken into account in the calculation of gross income. So that removes income amounts. So that uses the phrase any amount. And one expects certain words in legislation to have the same meaning throughout. And really any amount, I mean, what's the plain meaning of those words? It means any amount.
Especially where it was amended, though, Trevor. That to me is a huge point. It was subsequently amended. And that was dealt with in the tax court. And the tax court said it's not retrospective. Nobody argued it was retrospective. So the only way you can say amount excludes amounts of a capital nature at the time prior to the amendment is to say that the amendment was purely clarificatory. And that's quite a difficult argument, because then why do you bother to change the law if it already says what you want it to say? To me, that's a massive issue with this judgment.
Yeah. Let me just read how the judge put it. It's in paragraph 20. So the paragraphs 19 and 20 contain the real whoppers.
Agreed.
20 says, it bears mentioning that section 25B was introduced by the legislature in 1991. Logically, if capital gains did not exist, section 25B could not have been intended to apply to capital gains. Further, the insertion of other than an amount of a capital nature, which is not included in gross income, in the section after any amount. And she says here, which came about after capital gains was introduced. The amendment was promulgated on the 20th of January 2021. We're dealing with the tax years 2014 to 2016. So it's just not applicable. Is yet another indicator that this section does not apply to an amount of a capital nature. Now, as you say, if I remember Judge Binns Ward on several occasions when I've fallen foul of his judgments, he says that an amendment was purely expositionary. In other words, it's just explaining what the law always was. Now, I don't see how that can be said here. But if that was what she was trying to say, why doesn't she say so? As you said, and in the application for leave to appeal to the Constitutional Court, and I, have some insight into it, but I'm not primarily responsible for it. The reliance is placed on the fact that she's actually giving retrospective effect to that amendment, which in paragraph 13 of the tax court, it's spelled out very clearly that it only came into force in 2021. And that offends the rule of law. We're entitled to be ruled by law, and if something's amended subsequently, you don't apply it retrospectively. So that's a constitutional point. But also what that overlooks is that when Section 25B was introduced, it used the words any income. Didn't say any amount. It said any income. What is not stated, I'm reading from our editorial note, what is not stated is that when Section 25E was enacted in 1991, and for many years thereafter, the reference in subsection 1 was to any income. This was changed to any amount in terms of Section 27 of Act 32 of 2004, which was after the introduction of capital gains tax. And Meyerowitz on income tax says that that word could be wide enough to include capital gains. So to me, those are the two. As I say, a judge might hold that the 2021 amendment was merely clarifying what the position always was. But she doesn't deal with the fact that when it came in, it specifically said income, then it was changed to amounts.
And you just want the judges to reason that out, even if you don't ultimately agree with them, you mustn't feel like you read a judgment and feel like there's something obvious missing, especially when it comes from the SCA and was dealt with by the tax court in terms. That specific point was dealt with by the tax court. So, and obviously it was argued as well. So just to leave that out for me was a surprise.
And what was said in paragraph 19 about the taxable income nature versus capital gains nature, when in fact the one is the same as the other. There are 4 other judges who have to read the judgment and concur with it. Surely they would have picked that up. I mean, it's quoted in the judgment. Section 26A makes it absolutely clear. I don't know. I mean, a complete loss, It tends to suggest that the other judges don't bother to read the judgment. I can't believe that myself. I'm old-fashioned enough to think that cannot be the case. But perhaps they just did that in a perfunctory manner.
The difficulty is that your only remedy is constitutional court. And as you say, that's not a natural place to go for something like this. So it's not ideal.
Yeah, no, it's not ideal. Now, the Constitutional Court does now it is the apex court now, so it's not restricted to constitutional matters. But, I don't know, when you look at cases that have, 2 cases on Section 24C, which have gone, which surprised me, and others which I would have thought would go, which didn't. So, who knows? What's been said so far is really just scratching the surface, because there's a great deal more that can be said, but I just think one should focus on what are clear errors in the judgment. I don't think it's possible to deny that. And I don't know. It's very disappointing. I'm not speaking as in a partisan sense, but purely as a lawyer who has always had the utmost faith in our judicial system, it's sad to see a judgment written with such neglect is the only word I can use, and by the concluding as well.
Because the part that you've dealt with is kind of the substantive issue that the court looked at and applied their minds to. But just before we come on to understatement penalties, I just want to wrap up here, because I think the facts are quite unusual, if I can say that. So paragraph 80 in brackets 1 says that if you've got a South African trust and it vests an asset in a South African resident beneficiary, then the capital gain is disregarded in the trust and taxed in the hands of the beneficiary. And paragraph 80 in brackets 2 says, in the same circumstances, if the trust goes and sells the asset, realizes a capital gain, and vests the capital gain in the South African resident beneficiaries, then again, the capital gain is disregarded in the hands of the trust and taxed in the hands of the resident beneficiaries. And 99% of the time, those resident beneficiaries are not trusts. So I think the facts here are unusual. And is this going to move the needle in terms of my practice? No. Advice I give to clients? Not really. It's very unusual facts. So I think that is at least helpful. At least it's not something where you say, my goodness, this is something we deal with all day, every day, and how are we going to fix it? But the understatement penalties, Trevor, if you can move on to this, I thought that was very interesting. And I thought that was and that is something we deal with every day. And I thought that was a very interesting judgment, or part of the judgment.
Before we get on to the understatement penalties, can I just mention two things, if I hope I can remember. One is section 25B1 says that, and we mentioned it earlier, that to the extent that any amount is received for the immediate or future benefit of any ascertained beneficiary with a vested right thereto, it's deemed to accrue to that beneficiary. And then to the extent that that's not the case, it's deemed to accrue to the trust. Now, at the outset of the hearing, with Judge van der Merwe doing most of the talking, he made it quite clear that his prima facie view was that that capital gains get dealt with in terms of paragraph 80 of the 8th schedule, and income gets dealt with in terms of section 25B1. Now that may seem a logical approach, but as I pointed out to him, and let's not personalize this, but paragraph 80, both subparagraph 1 and subparagraph 2 only deal with resident beneficiaries. They don't deal with non-resident beneficiaries. And if you look at paragraph 2 of the 8th schedule, generally speaking, non-residents are not subject to capital gains tax, but they are subject to capital gains tax in respect of immovable property and the assets of a permanent establishment. So they are subject to capital gains tax. And so there's a lacuna there, in my opinion. Now, what mystifies me about this, because it's been, and I've been at a meeting at SARS with very responsible people, and they told me that opinion was divided within SARS itself, and that SARS has in many occasions, about 4 or 5 occasions, allowed the argument that in the case of a non-resident there was no CGT because the amount accrued direct to the beneficiary. Why don't they amend the legislation to make it clear? And surely all that's required would be an equivalent in paragraph 80 to what there is in section 25B1. To the extent that it's not deemed to accrue to any beneficiary with an asset with a vested right, then it's deemed to accrue to the trust. We'll do the same thing in paragraph 80. Then it's clear. Then we know that's the trust that must pay the tax, but it doesn't do that.
Doesn't do that, but I think there is 25B changing, I think does impact a little bit on that analysis, because now if in terms of paragraph 80, a trust sells an asset and makes a capital gain and distributes a capital gain to a non-resident beneficiary, then paragraph 82 does not apply, because it only applies to distributions to resident beneficiaries. So paragraph 82 doesn't apply, and the and the capital gain is not allocated to the beneficiary. So then you'd say, why isn't it taxed in the hands of the trust? And I think you'd have to go to section 25B and say, paragraph 80 doesn't help us. It doesn't deal with us. So, but in terms of section 25B, the capital gain is an amount that just flows through the trust and goes to the non-resident beneficiary, who, as you said, Trevor, is not taxed on it. The problem now is section 25B has been amended, and it says excluding amounts of a capital nature. So I think 25B has been, the door has been locked on that provision, and I saw that provision is quite important in arguing the flow through to a non-resident beneficiary. So I think SARS might say, you know what, we think we have in some way fixed this issue.
Well, I think if that's fixing it, I'm not impressed, because you know, it's like a half fix.
I agree. Yeah, it is. It's a, you know, it's reading something with something else and kind of saying, okay, well, maybe that's what's meant here. You know, but Trevor, that's good for us, because we're advisors. We don't, do we want simple law as advisors?
Well, it's nice to be able to advise people in confidence.
Of course we do.
But not only apply to income and amounts that do not, capital amounts that don't constitute gross income. So it has to
Trevor,
be.
talk to us about understatement penalties, because I'm interested in that piece.
I'm coming there. and then the other thing is, we offered about a main argument and then at least 3 alternative arguments. But our main argument was that section 8, paragraph 82 applied to the distribution from the Tier 1 trust to the Thistle trust, and that paragraph 81 applied to the distribution from the Thistle trust to its beneficiaries. And as you said earlier, I mean, this is an unusual set of facts. But why should it, as far as the distribution from the Thistle trust to its beneficiary concerned, why should it make any difference where that amount was derived from? I can't see why. And the question is it an asset? And maybe that's getting a bit too technical now. And, you know, there are a number of other provisions relating to all of that. But to my mind, the official SARS line is far too literalistic. You know, say paragraph 82 says that the trust that disposes of an asset and awards the proceeds to its beneficiary, the trust must ignore what's happened, and the beneficiary must pay the tax. But where the beneficiary itself is a trust, then surely that on distribution must also be taken into account with similar principles. And I don't see why it should matter how the Thistle Trust got its asset that it distributed. Anyway, that's enough of that. As far as the penalties were concerned, what actually happened in court, and the facts of the matter were that the taxpayer had relied on an opinion given by Meyerowitz many years ago. The opinion wasn't given to the Thistle Trust, was given to another trust in that same group, but it was on all fours. So the taxpayer relied on that. And the SARS argument was that the taxpayer had acted deliberately, and therefore it was not inadvertent. And for the taxpayer, we submitted that take the situation of a judge where an appeal court finds that a lower court has erred, has got something wrong, has made a mistake. Would anyone ever suggest that what the learned judge in the court Arquo got wrong was anything other than a bona fide inadvertent error? I don't see how you can suggest that. One's entitled to assume that judges act deliberately. In other words, they research a problem, they come to a conclusion, and they express their view. The SARS view seems to be that it's only if you put in an extra naught, or if you leave a naught out or something, just through carelessness, that's what an inadvertent error is. And what Judge van der Merwe said in court, he said the appellant's arguments on the understatement penalty are obviously correct, or they're not. And the SARS representative said, yes, my lord, they are. Conceded.
I think that's very, very powerful because, as you say, in terms of Section 222 of the Tax Administration Act, you can't have an understatement penalty if the understatement results from a bona fide inadvertent error. So what is that bona fide inadvertent error? And SARS has got a guide on understatement penalties. And they basically, as you said, Trevor, they say a bona fide inadvertent error doesn't result from deliberate tax planning. So it arises from an unthinking mistake, like a capturing error or something like that. And that's massive because every time you look at whether or not there's an understatement and understatement penalties, you look at bona fide inadvertent errors and you say, well, if that only applies to an unthinking mistake, that's a very narrow reading. And there are a couple of tax court cases. ABC Holdings is the one dealing with that issue. And they've said, I think rightly, that a bona fide inadvertent error is an innocent mistake resulting in an understatement when the taxpayer is acting in good faith. And that makes complete sense to me. But they're tax court cases, so they're not binding. So then you've got SARS's position in its guide, which goes contrary to the tax court cases. And they've got the SCA standing up and saying, here's paragraph 29, that the understatement by the Thistle Trust was a bona fide inadvertent error as it had believed that Section 25B was applicable to its case. Though the Thistle Trust erred, it did so in good faith and acted unintentionally. And I think that's very powerful. And that's very, as I say, that moves the needle in terms of the stuff that we advise on all day, every day.
No, I think maybe what I should do in the taxpayer is actually quote from the taxpayer's heads of argument on that specific point, and then say SARS conceded it on that basis. Under pressure from the judge, yes, but still.
I think it'd be great because they just say the point was conceded, but you kind of left hanging and saying, well, how was it conceded? How did that happen? What was the background to that? So I think it'd be great to kind of get some color and context on that because this is really a big point for us.
Yeah, absolutely. And I mean, to me, it's perfectly obvious. In the example of a judge just brings it home. Because probably all judges who reached the SCA have been overturned themselves when they were in a lower court. It happens, that's life. No, we're all human, we make mistakes. Sometimes, like, I think Judge Wright was correct and the SCA was wrong in this matter, but that's just my opinion. But you can't say that it was anything other than a bona fide inadvertent error.
And it's actually quite interesting because the definition of understatement includes an incorrect statement in a return. And Trevor, we've chatted about this briefly. If I believe my tax position is correct and I fill out my tax return on that basis, I don't think that's an incorrect statement in a return just because SARS disagrees with it. So they disagree and they give an additional assessment and I say, but hang on, that's not an incorrect statement. That's just my view of the world after I've taken advice. And you've got a different view of the world. But I think an incorrect statement means something that's objectively wrong. You said you didn't get gross income and you did. You said you didn't make a capital gain and you did. That's just an incorrect statement. So I think with something like this, I would just question whether, in fact, you get into the definition of understatement. Is there an incorrect statement in a return? And it's only if you have an understatement that you have to look at, okay, well, you don't have understatement penalties if it results from a bona fide inadvertent error. So I think you've got almost two shots at that as a taxpayer.
Yeah. And I mean, those understatement penalties are pernicious because there's no discretion involved. It's just laid down by the I think it's iniquitous myself, but anyway.
But I think that's a very positive piece of this judgment. And I'm very interested in your point that SARS are cross-appealing. Like, on what basis are they cross-appealing on that, on something that's so clearly right and has been upheld by tax courts and is just logical and obvious? Because their guide says something else. I mean, that's wow. Well, I hope that part doesn't get overturned. That's for sure. If it does end up in the Constitutional Court, but that I'd be prepared to wager. Hey, Trevor.
Yeah, no. I can't see that happening.
I'm not a betting man, but I tell you, that's almost as unlikely as Harry Kane missing a second penalty by kicking the ball over the crossbar. Sorry.
Yeah.
Oh, it's late.
Perhaps that's
So
a suitably frivolous note on which to end.
probably is. Very good chatting, Trevor. And yeah, I look forward to hearing the next round in this, because I think there's at least, well, there's certainly one round to go, hopefully.
Yeah, hopefully, we'll see. I, I would think, I know the Constitutional Court, it's got to be in the interests of justice. They define that in their own particular ways. So it's got to be important. But when you've got such glaring errors from the Supreme Court of Appeal, I don't know how you can leave something like that. It just messes up our jurisprudence. I would think that's in the interests of justice to fix it. They might still come to the same conclusion for different reasons. We're not I'm not wedded to the conclusion, but it's the reasoning that's the problem.
Anyway. Like chatting, Trevor, as always, and we will have a good end of the year.
From the 16th of December to the 15th of January, we can not worry about the DAs. So many business days to get things done.
Exactly, and take a proper break and think of something other than tax. So
exactly. Yeah.
So thanks, Trevor.
Peter, thanks very much. Nice to chat.
Thank you. You too.
Bye-bye.